Welcome to Property Law 101. I am Sara Bronin, and I created this series to help you understand the basics of property law. We cover 4 fundamental questions about property and property law, and today we are talking about the third question, which is using property. And we will look at this question through the zoning example, so zoning being the public regulation of land use structures and lots through the assignment of lots to distinctly regulated districts. In the video about the transition from nuisance to zoning, we talked briefly about the history of zoning and how zoning really started taking off in the 1920s. There is a specific reason for this, and that is the 1926 U.S. Supreme Court decision of Village of Euclid versus Ambler Realty. So we'll transport ourselves over to the Cleveland area. Euclid was a suburb of Cleveland. There's nothing particularly special about Euclid. It's just like any other average city in the United States emerging at this time. But what is special, of course, is that it's the subject of a key case on zoning. In this case, we get a long description of the zoning code and the various districts that are embedded within Euclid's zoning code. In Euclid, zoning was pyramidal, so each subsequent district encompassed prior districts. So for example, the U1 zone in Euclid, Ohio, the top of the pyramid, allowed single-family dwellings, public parks, and other uses. The U2 zone allowed two-family dwellings and all the uses allowed in U1. The U6 zone, I'm making a pyramid here, included sewage facilities, scrap yards, cemeteries, manufacturing, industrial uses, all pretty undesirable uses. In addition to that, included all the uses in U1 through U5. Note that this kind of pyramidal zoning doesn't really exist today. Usually the categories are mutually exclusive. So that's the zoning scheme generally. Now what we have to consider is what kind of zoning is on Ambler Realty's land. The company owns one pretty big parcel, but that one parcel is designated to be 3 different zones, U2, U3, and U6. So we've talked about the U2 and U6 zones. The U3 zone allowed apartments, hotels, churches, schools, and other civic buildings. Because the parcel was designated for 3 different zones, it was hard at the time, it was hard to maybe speculate as to what its economic value is. But the court tells us that for industrial uses, those are worth $10,000 an acre. For residential uses, it's only worth $2,500 an acre. In other words, the parcel could be worth more if it was all used for industry. So that's why you see this company is suing. It's suing to declare the zoning regime is unconstitutional. At the time of the case, Ambler Realty is not actually doing anything to the property. In other words, they aren't building, they aren't seeking a zoning permit. The zoning code is not therefore being applied to them. As a result, the kind of challenge they are bringing is a facial challenge. A facial challenge alleges that the term of the ordinance is unconstitutional as written. So these are challenges that are much harder to win than as applied challenges. So facial challenges are always harder. The overwhelming majority of zoning lawsuits today, by the way, relate to the way zoning codes have been applied to a particular site or a particular project, or applicant, I should say. So now the question before the court is whether the ordinance is justified under the police power. The court first talks a lot about what zoning might have the power to do: to segregate residential, business, and industrial buildings, to make fire service easier, to increase safety and security, to reduce traffic and congestion. But there was something else the court said zoning does. And that is that zoning regulates apartment buildings and housing uses. The court, in saying this, called apartment buildings, quote, mere parasites, end quote. This language is somewhat disturbing and reflected the prevailing view then and possibly now too. If apartment buildings are parasites, what is the Supreme Court really saying about the people who live in those buildings? We discussed this in our video about whether people are nuisances. We also discuss zoning's role in taking this view on in another video about exclusionary zoning. After considering what zoning codes do, the court then turned to the standard for constitutionality. In this case, to be unconstitutional, the zoning ordinance would have had to be found to be clearly arbitrary and unreasonable, and or having no substantial relation to the public health, safety, morals, or general welfare. According to the Supreme Court, the Euclid ordinance does not, in fact, violate this standard. So the court upholds the constitutionality of zoning as well within the legitimate scope of the police power. The decision here gave local authorities confidence that their zoning regulations would pass constitutional muster. So again, we're in 1926. So that's why you see after this time, more communities beginning to adopt zoning codes in the decades after. In fact, every major city in the country has zoning except for Houston. Euclid is, of course, a federal case dealing with zoning, but don't let our focus on this case fool you. Usually the federal courts stay out of zoning and they leave the interpretation of zoning codes and the state laws that enable them to the states and to state courts. So if you want to know what the particular legal constraints are today on zoning codes in your jurisdiction, you should review state level laws and decisions, and you should review laws that go beyond this very simple facial challenge at the Supreme Court 100 years ago. So I will leave it there. I'd love to hear from you through Twitter or on my website where you can sign up to my mailing list. See you next time.